California just made a bold move that could reshape the future of artificial intelligence, and it's already sparking debate. On September 29, 2025, Governor Gavin Newsom signed Senate Bill 53, the Transparency in Frontier Artificial Intelligence Act, TFAIA, into law, marking a significant milestone in AI regulation. But here's where it gets controversial. California is now the first state to demand that leading AI developers publicly disclose their safety frameworks, explain how their models could pose catastrophic risks, and detail how they plan to mitigate those risks. This law doesn't just stop at transparency. It also mandates whistleblower protections, incident reporting, and even the creation of a public cloud computing cluster called CalCompute. But why is this such a big deal? Because California, home to the nation's largest economy and most AI companies, is charting its own course on AI regulation, potentially clashing with federal efforts. And this is the part most people miss. While the law currently applies to a narrow group of AI developers, its scope is expected to expand rapidly as more models meet the technical threshold for being considered frontier models. The TFAIA requires frontier developers, companies training advanced AI models using immense computing power over 10 to the 26th flops, to publish detailed frameworks for managing catastrophic risks. These risks include scenarios like AI models assisting in the creation of weapons of mass destruction, engaging in cyber attacks, or evading developer control. Here's the kicker. The law doesn't explicitly limit its reach to California-based companies, meaning it could apply to any AI developer selling products in the state. This raises questions about enforceability and compliance, especially as federal and state regulations diverge. Large frontier developers, those with annual revenues exceeding $500 million, face additional requirements. They must publish transparency reports detailing their models' intended uses, restrictions, and risk assessments. They're also obligated to report critical safety incidents to the California Office of Emergency Services within 15 days of discovery. But what happens if a federal law imposes similar or stricter standards? The TFAIA includes a deemed compliance provision, allowing companies to meet California's requirements by adhering to equivalent federal policies, a subtle nod to the ongoing tension between state and federal AI regulation. Whistleblower protections are another cornerstone of the TFAIA. Employees, contractors, and affiliates of frontier developers who report violations or raise safety concerns are shielded from retaliation. This includes the right to report anonymously and seek legal remedies if retaliated against. Is this enough to ensure accountability in the AI industry? Some argue it's a strong start, while others worry it may not go far enough to prevent misuse. Beyond regulation, the TFAIA promotes innovation by establishing a public-private consortium to develop CalCompute, a state-managed cloud computing cluster aimed at supporting ethical AI research. This initiative underscores California's dual focus on oversight and advancement in the AI space. But will other states follow California's lead? New York's RAISE Act, awaiting the governor's signature, suggests a growing trend towards state-level AI regulation. Meanwhile, states like Colorado, Utah, and Texas have already enacted laws targeting specific AI applications, such as high-risk systems or non-consensual imagery. California's approach, however, stands out for its focus on the inherent risks of advanced AI models, regardless of their application. Internationally, California's move aligns with efforts by the European Union, Japan, and South Korea to establish risk-based AI regulatory frameworks. Yet, the TFAI's unique requirements, like mandating transparency for a narrow subset of developers, are sure to spark debate in global regulatory discussions. Is California setting a new standard or overstepping its bounds? The answer may depend on whether federal legislation emerges to preempt state laws. For now, AI developers must navigate this evolving landscape. Frontier developers should assess their transparency practices, draft compliance frameworks, and monitor developments related to CalCompute. As California takes the lead, one question remains. Will this law protect us from AI's risks or stifle innovation? The coming years will tell, and your voice in this debate matters. What do you think? Share your thoughts in the comments below.